Welcome to Bloomberg Law. I'm Pacchia. My guest today is Nina Totenberg, legal affairs correspondent at NPR. She is considered to be the grande dame of the United States Supreme Court reporters, with more than 30 years on the beat and countless awards and accolades for her coverage. We're pleased to have her join us from Washington, D.C. Nina, thanks so much for joining us today. Welcome.
It's my pleasure.
So, wanted to start off by getting your thoughts on how coverage of the court has changed in recent years. With last month's healthcare decision, there was a great rush to report the ruling first, and both CNN and Fox News, in their effort to do so, got the ruling wrong. NPR was correct, but they didn't report the ruling until something like 8 minutes after other news organizations correctly reported that the mandate had been upheld. How do you strike the balance between being first and being right in today's media?
Well, we made a decision to be right, and we had Morning Edition on the air on the West Coast, and we don't actually have a system for breaking in with headlines except if something truly urgent happens, like a war breaks out or there's a terrorist attack. That we break in immediately, but everybody knew we were going to get this decision. Everybody knew that in a matter of 10 to 15 minutes, we would know what the outcome was. And interestingly, Bloomberg was first, but the AP, Thomson Reuters were seconds behind. All of the wire services got it right. And what's most interesting to me is that the television cables that got it wrong didn't bother to look at the wires. They literally didn't look. They subscribed to these services, and they didn't look. They didn't check with SCOTUS blog, which is the leading reporter on, sort of blog reporter on the Supreme Court, and was trying to be as quick as it possibly could be, but also be accurate. They didn't check the places where people cover these institutions like a blanket. Instead, they had this sort of chain reaction kind of reportage where the producer is inside, the reporter's outside, there's a control room in Atlanta, there's a control room in the Washington Bureau, and there's not a central sort of command post, and the person who knows the most doesn't take the time, because the pressure is enormous, to make sure that that you read past the first paragraph. You read the first paragraph, you get it wrong.
Yeah. So, I mean, it sounds like the emergence of social media channels has meaningfully changed the way you cover the Supreme Court. Could you talk to us a little bit more about how things are different now?
Well, in the normal run of the case, it's not different, because you don't break into normal programming. Cables don't normally report on what the Supreme Court does in an instantaneous fashion. Neither do the so-called over-the-air networks, NBC, CBS, ABC. Nobody breaks into programming for Supreme Court decisions. Okay, they do something very important, like they did just a few days before, when they struck down most, but not all, of the Arizona immigration law. And it was clear, it was very complicated, and nobody tried to get that on in a matter of 30 seconds because it was clear they were going to get it wrong.
Right.
And they hadn't set it up. This was the ACA. This was the president's signature legislative achievement. And this is an election year. And that is what made it very different.
Nina, I couldn't help but notice that you have a Twitter feed, but you've used it only about 40 times in the last approximately 3 years. I got to ask, do you and Twitter not quite get along?
I don't have time. I don't know where people have time to tweet. I don't have time. On the day of the decision, I was actually in the courtroom. So I wasn't out on the steps. I was in the courtroom. Our idea at NPR was we would be hooked up to the call with SCOTUS blog. We would be watching the wires, and we would break into Morning Edition at the first obvious break, when there was a pause between stories, and say what the result was. And when we were sure, and we had editors sitting there who were the bosses. We have it from here, we have it from here, we have it from here. We're sure we can go, and then there's an email to the newsroom, you can go with it. Mm-hmm. But I was in the courtroom. I actually left the courtroom before Justice Ginsburg finished her dissent, because I looked at the clock and it was 13 minutes of 11, and I was supposed to be on the air at 11. But I actually knew what the court had done. It was very crystal clear if you were sitting there, right, all the things it had done. So first I'm on Morning Edition. Then I do the newscast. I do a number of things that will serve the newscast unit. Then I go back and I did 5 interviews that we had pre-set up. Then I wrote my All Things Considered piece. Then I did 5 more interviews for the morning edition piece. Then we did an hour-long special, and then I wrote the morning edition piece. Where in there am I going to tweet?
It's hard. There are so many new kinds of news organizations that now have full-time Supreme Court reporters, such as we're talking about Huffington Post here and SCOTUS blog, like you mentioned before. Are the competitive pressures more intense today than when you began on the beat?
I'm not sure, but I don't really think so, because when I began on the beat, there were a lot more newspapers that covered the court. So there was competition from a different angle. And really, the number of people who regularly cover the court, most of the oral arguments that are of any newsworthy interest at all, and show up for all decision days, that number is probably fewer than 24. That's a pretty small press corps compared to the hundreds and hundreds who cover the Hill or the White House. And those people, by and large, know what they're doing. The problem is it's very difficult to convince other people that you change a word and suddenly everything's different in the story.
Now, as you know, after the healthcare decision was released, there were leaks that Chief Justice Roberts switched his vote in late May or early June to uphold the individual mandate under the taxing power. You said it was, quote, amazing that the leak was targeted in a way that is clearly meant to detract from the good reviews the Chief Justice was getting in many quarters. Is it your view that this is a political hit job, or is that the view of the dozen or so anonymous sources that your report was based on?
I think it's a little of both. First of all, I think the way this story was framed, that he, quote, switched his vote, misperceives the process. People often change their views when they start to write something or when they start to put it down on paper. It doesn't stay the same. And the numbers of times that people change their votes, or it's not really switching your vote, change their views, are legion. Now, it's probably rarer that the opinion writer changes his or her view diametrically, but I have no reason to believe that the Chief Justice actually did change his view diametrically. I think that he was very clear from the beginning that he did not think the ACA could survive under the Commerce Clause, but that he was much more ambiguous and ambivalent about the taxing power, and that when he went to think about it and to start writing it, and he assigned the opinion to himself, that became clearer. And when the 4 and the minority realized that they had lost, they were angry. They were very angry. That is not unusual either. You know, when you have a very big, high-profile case, I know that the liberals were very angry at the end of Bush versus Gore, and they felt that there were some things that were done that were not appropriate, and they got over it. And I'm sure the conservatives will get over it in this case eventually too. What really made this different was that it's not unusual that you find out what happened more or less or to some degree years later. But it's very rare. In fact, in modern times, I can't remember a case of when you find out on a contemporaneous basis, the week of, about the sort of the deliberative process in a major decision. That is very unusual. I mean, I think I broke a story that was remotely like this about 30 years ago, I think.
Right.
But it wasn't about a decision. It wasn't about a decision. It was about whether or not the convictions in the Watergate case were going to get reviewed. It was about whether the court was going to grant cert or not. And after it had been sitting there for many weeks, I started probing to try to figure out what was going on.
Right.
And I was able to report a little of that. But this is quite different, and it had the earmarks of somebody or somebody or two bodies who were very angry. Now, that's not necessarily a justice. It could be a justice, could be a law clerk, could be a spouse of a justice. You just, one of the things I don't try to do is figure out who another reporter has found as a source, because I don't really want people doing that to me.
You've said in the past that you were friends with people on the court, and I presume, correct me if I'm wrong, that you're friends with some of the justices currently on the court. Are the justices?
I am.
Can you tell us which ones?
I like to think that I know to a various degree most of the other members of the court, and of all different ideological stripes. I knew Justice Scalia, for example, when he was on the D.C. Circuit. That's when I first got to know him, and I used to have pizza with him. He's I'm very fond of him. I'm extremely fond of Justice Ginsburg, and I know other members of the court and former members of the court that I think are my professional friends, is the way I would put it.
Does that make your job easier or harder, or does it all wash out in the end?
I think it all washes out in the end. You know, you never talk to a justice about the court's business. It's really improper. And if you did that, they wouldn't talk to you at all. And so you just, you know, there are times when I've reported things about people I know and like where I was sorry I had to do it, but it's your job. Right. You just have to do it.
That's life. Do you get the impression, though, that whether justices themselves are either worried or concerned that leaks might occur, perhaps like the one that we just saw concerning Chief Justice Roberts, or is this something more that the clerks are worried about?
Well, the justices are really worried about it. They're always worried about it, and I'm sure that there will be a sterner than usual conversation with the clerks, the new clerks coming in, and most of them come in August. They're always warned very hard that this is a position of great responsibility and confidence. And because these aren't secrets that dozens and dozens of people know, maybe at the most, by the time you're talking about all the administrative people who have to collate the pages and the printers and everything, maybe at the maximum you could figure that 30 or 40 people know the outcome of a case. And it's really dangerous to report the outcome of a case before it happens because they do change. I've known cases, I remember there was one case back in I think the 70s, where the outcome was reported by somebody and it changed. Over the course of the next few weeks, the outcome actually changed. This is not that unusual. So I have to say that if somebody had handed me the opinion in the ACA case, I would have been scared to death because I do know that these things change and the emphasis changes too.
Right. So news organizations this time around asked the court to televise the healthcare oral arguments and the announcement of the decision. Both those requests were denied. Do you think we'll ever see cameras in the Supreme Court in your lifetime? And if so, how would that change public opinion of the court?
I'm not sure how it would change it. On the one hand, you could say that people would have a much better understanding of what the court does, and they would see that these are serious people who really do their homework. On the other hand, most people won't watch the whole argument, and even if they do, they may get a misperception. For example, most people thought, me included, based only on the oral argument, and I knew enough to sort of shove it back down my throat, but based only on the oral argument, you would have thought that the Supreme Court was going to strike down the Obama health care overhaul. And so it tells you something about the court, but it doesn't tell you as much as most people think. And I think that, for example, when the RNC ran a loop of Don Verrilli, the Solicitor General, who aspirated some water at the beginning of the ACA argument, it went down the wrong pipe, and he couldn't breathe, and he was literally choking, and the RNC ran a sort of a parody of it. And I think that's exactly the kind of thing, I know this is a fact, that really troubled the court, really ticked it off. And it makes it less likely that there would ever be television or even regular audio of Supreme Court arguments. They make the audio available at the end of every week. Anybody who wants to hear a Supreme Court argument can hear it at the end of every week. You just go to the court's website and you can listen.
No, you just can't see the reactions on their faces. Nina Totenberg from NPR, I want to thank you so much for your time today. This was a real pleasure.
It's my pleasure too. Thanks, Lee.
If you'd like to learn more about the cases and issues we just discussed, be sure to check out our offerings on BloombergLaw.com and also on the Bloomberg Terminal. You can see more of our videos on YouTube, and you can follow our updates on Twitter. I'm Lee Pacchia. Thanks for watching.